Court judgment on section 148 of income tax. There are controversies and issues on that judgment. It's recently passed by Supreme Court. To discuss on this issue, we have an eminent speaker, none other than CA Naveen Khariwal, sir. Welcome you, sir.
Yes, sir.
I welcome all the members for this unique program. Hope this will enrich your knowledge. I request our secretary Pramod to welcome our speaker Naveen Khariwal with bouquet. Thank you, Pramod. Now I request our MC member Shripal to give a brief introduction of today's speaker Naveen Khariwal. Over to you, Shripal.
Good evening, everyone. So it is my pleasure to introduce today's speaker, CA Naveen Khariwal. So he's a BCom FCA. He is in practice. He's a partner at HC Kincha & Co. and HC Kincha & Associates. He comes from a family of chartered accountants. Grandfather, father, and brother are also chartered accountants. His specialization is in direct taxes. He's a co-opted member of the Direct Taxes Committee of ICAI, New Delhi for the year 2021. Member of Central Taxes, Corporate Laws and GST Committee of FKCCI Bangalore. Member in Finance Advisory Committee of the KSCA, Karnataka State Cricket Association. Member of the Study Circle or the Study Group of Committee of Chamber of Tax Consultants, Mumbai. Was also part of team nominated by Bangalore branch of SIRC of ICAI to represent before Honorable Justice R.V. Ishwar Committee for Simplification of Tax. Coordinator and moderator of Jignasa, one-day workshop on scrutiny, survey, summons, search and seizure. Speaker, coordinator and moderator of one-day workshop on issues in assessments, reassessments, e-assessments and various other topics which are organized by branch of ICAI. Coordinator and moderator of one-day seminar while filing a P3CA, which was organized by the Silent and Spam WIRC. He is also a speaker at seminars organized by various branches of ICAI across India. He was a very well-known speaker and presentation at various forums like FKCCI, corporates and others. So with this, a warm welcome to CA Naveen Khariwal, and over to you, sir.
Thank you, sir. Yeah, share. This one. Full screen. Yeah, now we can. Function. I think that button, mouse button is there. Yeah, members. Last week I had been to Madkeri for this RRCA, where we discussed about the issues in the new substituted provisions of section 148, 147, newly introduced section 148A, 149 and 151. So taking that discussion forward, the chairman, told me to, once the Supreme Court judgment was out on 4th of May, Ashish Kumar and others by Supreme Court on delivered judgment on 4th of May by Justice M.R. Shah and Justice B.V. Nagaratnam. The chairman told me to continue the discussion on 148 on all the aspects of, and controversies of the Supreme Court. So I think a lot of people are logged online, and it should be so, rightfully so, because of the, the incessant rains Bangalore is facing of late. So I can see a lot of people online, and what I'm going to, at the inception, what I'm going to discuss are purely my personal views, which are not binding on anybody of you. So how do we read the Supreme Court judgment? What we have to go is now, we will go through the Supreme Court judgment, para-wise, and then we will discuss all the, the directions coming out of the Supreme Court judgment, the conclusions coming out of the Supreme Court judgment, as also the issues and controversies which are coming out of the Supreme Court judgment. So let me begin my presentation. This prior to Finance Act 21, there was this reassessment provisions. Old provisions were always there. 147 income escaping assessment, 148 is notice before issue of notice for completion of assessment, notice under 148. 149 was time limit subject to which assessments could be completed. 151 was the sanction. Now it has become specified authority. So all these provisions are there in the Income Tax Act from 1961, save for 2 years in between, in 87 to 89, else 60 years they have stood the test of time. And because, the government, the department, the finance ministry was of the opinion that these provisions, has led to a lot of litigation. More than 60 years they have stood the test of time, and you will have got umpteen Supreme Court cases, deliberating on various issues like reason to believe, tangible material, rational, etc. So a host of Supreme Court judgments. Now what they have done is from Finance Act 21, they have, substituted by altogether new provisions of 147 income escaping assessment. They introduced a new section 148A, altogether new section 148A. Then they substituted all the provisions of 148, 149, 151. New section introduces 148A. Now, what we'll do is we will slowly go through the provisions also, and then we will jump into the Supreme Court judgment. Now, members, if you see the new section 147, which has been incorporated with Finance Act 22, I am taking you. Now, Finance Act 22, if you see, it says any income chargeable to tax, escaped assessment for any assessment year. The assessing officer may subject to provisions of section 148 to 153. So this provisions 147 is subject to provisions of 148 to 153. He may assess or reassess or recompute the loss or depreciation or any other allowance or deduction for any assessment year, subject to the provisions of 148 to 153. Very simple section. They have toned down the section. They have, made it all simple. There is one explanation to 147. What is the explanation saying? It is saying that for the purpose of assessment or reassessment for this section, the assessing officer in the course of reassessment proceedings may also assess or reassess the income in respect of any issue which has escaped assessment, and such issue comes to its notice subsequently in the course of proceedings under this section, irrespective of the fact that the provisions of section 148A have not been complied with. So under the new regime, my dear friends, what has happened is before you issue 148 notice, you have to follow the dictum of 148 capital A. We will see what is 148 capital A. What is 148 capital A? It is nothing but a reproduction of the Supreme Court judgment in the old regime of GK and drive shaft 259 ITR 19. So what was it in the earlier, regime? There was a Supreme Court judgment of GK and drive shaft, which gave, it's a judge-made law, basically. There was no such section in the Act. What was the judge-made law in the earlier regime, GK and drive shaft? What did the court tell Supreme Court? Hey, the department issued a notice to you under 148. All you have to do is first file a written in response notice under 148. Then you ask for a copy of reasons recorded. Once you ask for copies of reasons recorded by writing a letter to the concerned assessing officer by attaching a copy of acknowledgement for having uploaded the return under section 148, the department is bound to give you copies of reasons recorded, for which you can file your objections. Once you have filed the objections, the department is going to dispose of the objections as if it is an order, speaking order, by way of a speaking order. So all these steps, are now being built, now being incorporated under new section called 148 capital A. What is 148 capital A? Clause A, conduct any inquiry if required. 148A clause B, give a show cause notice to the assessee. 148A clause C, consider the reply of the assessee. That means to say, give opportunity of assessee of being heard. And 148A clause D is what? After considering the reply of the assessee and the material available on record, you pass an order under section 148A clause D, saying that whether it is a fit case for assessment or it is not a fit case for assessment. These are the steps under 148A clause A, B, C, D. I repeat again, 148A clause A is conduct any inquiry if required, which I don't agree with. They are telling conduct any inquiry if required, means none of the assessing officer are going to do the inquiry. 148A clause is telling show cause. In my opinion, the show cause should have preceded the inquiry. First you issue show cause. You don't want to do inquiry, then you issue show cause notice to the assessee, and then you gather all the information from the assessee. It is not correct, sir. This is not the sum and substance of the new assessment procedures. It is your bound and duty to do the inquiry, take that material, put it before the assessee and tell him, this is what the material is. Now you can file your objections. But they are telling, I will not do conduct any inquiry if required. It is not mandatory, not compulsory in law. Then you are giving show cause notice to the assessee, which is in nature of fishing and rowing inquiry. You are collecting all the details. 148A clause is telling, give opportunity of being heard to the assessee, and then pass an order. 148A clause D. So what is 148A clause B? They are telling minimum 7 days time I shall give to the assessee. Maximum I shall give 30 days time. Or the section also says within such time as may be extended on an application filed by the assessee. So minimum 7 days time I'll give the assessee to respond to my show cause notice on 148AB. Maximum I can give 30 days time. Or the law is telling, the section is telling 148A clause B, also I can extend the time limit subject to an application filed by the assessee. Then after, they are telling 148AD, I'll pass an order. What is the time limit for passing such an order under 148A clause D? The section is telling 30 days from the end of the month in which notice under 148AB is served. Or if the assessee has filed a reply, fine. 30 days from the end of the month in which reply is received. If the reply is not received, 30 days from the end of the month in which the time limit to reply expires. So that is sum and substance of 148A. Now, 147, that's what I wanted to discuss. What are they telling in the course of reassessment proceedings? If the assessing officer, finds out that any other income of the assessee has escaped assessment, I told you the first step in reassessment now is 148 ABCD. Then only you can issue notice under 148. So what is 147 telling? In the course of reassessment proceedings, if I were to find out that in income of any other issue which has escaped assessment, and such issue is coming to the notice of the assessing officer in the course of reassessment proceedings, irrespective of the fact that the provisions of 148A have not been complied with. So here they are telling, I am bidding goodbye to the decision rendered earlier at a Jet Airways case, Bombay High Court, etc. So I am telling now, nothing doing. For example, what is the information? Earlier it was reason to believe. Now they are telling, what is the word, sir? Now they are telling information suggesting that income has escaped assessment. The word reason to believe has been removed from the statute, was there for more than 60 years. Instead of the word reason to believe, there is a word called now information suggesting that income has escaped assessment. So they are telling, there was information, what? Income at Mysore has escaped assessment. In the course of reassessment proceedings, you came to know that income at Bangalore had also escaped assessment. So therefore, he is telling, sorry, in 148A, there was information only that income at Mysore had escaped assessment. But now even at Bangalore, which has escaped assessment, although I didn't follow the procedure for 148A, I can easily reopen and bring to tax the undisclosed income. Now, section 148. Now, what is section 148? He is telling, before making any assessment under 147 and subject to provisions of 148A. This is the new line which is added in the statute in 148. Subject to provisions of 148A. I told you 148A will precede 148. 148A section will precede 148. Then the assessing officer shall serve on the assessee a notice. The service, the Supreme Court has already delivered a judgment, landmark judgment in R.K. Upadhyay for Shenabai Patel, long back. Service is of utmost importance in 148 issue. So provisions of 148A shall serve on the assessee a notice along with a copy of order. I told you 148 AD, you need to serve a copy of the order. So 148 along with that 148 AD. Then you can tell him to file the return within such period as may be prescribed. Now, there is a one proviso. What it says? Provided no notice under this section shall be issued unless there is information with assessing officer which suggests that income chargeable to tax has escaped assessment in the case of assessee for the relevant assessment year and the assessing officer has obtained prior approval of the specified authority. Sir, specified authority is nothing but sanction under section 151. Earlier, what was it? A sanction. Now it is what? Specified authority is issuing the permission under 151. There are only two specified authorities now. Right from Principal Chief Commissioner and Commissioner. That's all. No other authorities. So what are they telling? No notice under 148 shall be issued unless there is what? There is information with assessing officer which suggests that income chargeable to tax has escaped assessment. We will see the meaning of information also. For now, you have to be alert now that no notice shall be issued unless there is information with the AO which suggests that income chargeable to tax has escaped assessment. And also you should have obtained the prior approval of the specified authority under section 151. Now, second proviso says that this was an amendment made in Finance Act 22. This wasn't there in Finance Act 21. Provided further that no such approval shall be required where the assessing officer with the prior approval of specified authority has passed an order under clause D of 148A to the effect that it is a fit case to issue notice under this section. Now, earlier, there were 4 or 5 approvals. In 148A, every stage you have to take approval. Conduct inquiry, approval. Again, show cause notice, take approval. Again, giving opportunity to the assessee, approval. Again, you want to pass order 148 AD, approval. Every stage they are telling, you please take approval and then proceed. But here they brought in a proviso saying that once you have passed an order of 148A D, what is 148A clause D? Saying that it's a fit case for reassessment. It is a fit case that income has escaped assessment. Thereafter, please do not take again approval for issue of notice under 148. You can very well issue notice under 148 without any approval, provided already there is an approval in place before passing of order under 148A clause D. Very simple. That is the second proviso to 148. Now, there is explanation. There are 2 explanations to 148. I require your complete attention. Very, very important. What is explanation 1? Explanation 1 will give you the meaning of information suggesting that income has escaped assessment. Explanation 1 is what? Information, obviously with the assessing officer. Who is an assessing officer? Defined within 2 within bracket 7A of the Act, which suggests that income chargeable to tax escaped assessment. What is assessment? 2 within bracket 40 of the Act defines the word regular assessment to mean an assessment made under 143.3 or 144. 2 within bracket 8 says assessment includes reassessment. Anyway, so information suggests that income chargeable to tax escaped assessment means, listen carefully, Finance Act 21, there are only 2 types of information. Finance Act 22, there are 5 types of information. So what was the information in Finance Act 21? There were 2 types of information which said any information flagged in the case of assessee for the relevant year in accordance with RMS formulated by board from time to time. My dear friends, the same thing continues except that the word flagged has been deleted in the statute in Finance Act 22. In Finance Act 21, I repeat again, there were 2 types of information only. Any information flagged in the case of assessee for the relevant assessment year in accordance with RMS formulated by board from time to time. Same definition of information in clause 1 is carried forward to Finance Act 22, but the word flagged is deleted in the statute. Again, the second meaning of information, clause 2. Earlier in Finance Act 21, what was it? Any final objection raised by C&AG of India to the effect that the assessment in the case of the assessee for the relevant assessment year has not been made in accordance with the provisions of this Act. Earlier, objection raised by C&AG. Now that C&AG is deleted, the word C&AG is deleted in Finance Act 22, and they only say it has become more dangerous. Earlier, what? Objection raised by C&AG, final audit objection. Now they say any audit objection. Now the law has become all the more dangerous. They say any audit objection, whosoever the authority may be. It may be RAP wing or IAP wing or assessing officer himself. Any objection, 154 notice, etc. So any audit objection to the effect that the assessment in the case of the assessee for relevant assessment year has not been made in accordance with the provisions of this Act. The third type of information is information received under a DTA agreement referred to in 90 or 90A. Fourth one is information available to the assessing officer under a scheme notified under section 135A. That is your faceless assessment, faceless reassessment basically. Fifth information is information which requires consequence, action, which requires action in consequence of order of tribunal or court. Now explanation 2. My dear friends, explanation 1 gave you the meaning of information suggesting that income is chargeable to tax. Explanation 2 is giving the meaning of deemed information. Be careful, what is deemed information now? Explanation 2 is telling, for the purposes of this section, where a search is initiated under 132 or books of accounts or other documents or assets are requisitioned under 132A on or after 1st day of April 21. In the case of an assessee or survey is conducted under 133A other than subsection 2A. Other than subsection 2A is your TDS TCS survey. Subsection 5 was there in Finance Act 21. That subsection 5 is deleted in Finance Act 22. What was it? Your event, ceremonial, marriage survey, etc. On or after 1st day of 21 again. Number 3. The assessing officer is satisfied with prior approval of the PCAT or CAT that money, bullion, jewelry or valuable article or thing requisition under 132 or 132A in case of any other person or on or after April 21 belongs to the assessee. That is your 153C, you know, earlier type 153C was there, sir. That is now incorporated in the 3 and 4. What is 3? It says only money, bullion, jewelry, valuable article or thing under 132 or 132A requisition. What is requisition? Maybe, you know, CBI, GST, VAT, etc. Whatever is requisition under that act becomes an information under the Income Tax Act. So 153C type cases are included in clause 3 and clause 4. What is why 153C 2 sections are there, sir? 3 and 4 now. First one says money, bullion, jewelry or valuable article or thing requisition 132 or 132A in case of any other person on or after 1st of April 21. Or 4 says books of accounts, documents seized or requisition. There it is money, bullion, jewelry, valuable article. Here it is books of accounts, documents seized or requisition. Same thing. 132, 132A. In the case of any other person on or after 1st day of information. Pertains to or pertain to any information contained therein relate to the assessee. So these are the 4 types of deemed information. Then it continues section. The assessing officer shall be deemed to have information. Very important to understand. When deemed to have information which suggests that income chargeable to tax has escaped assessment, when books of accounts, documents or any assets are requisitioned or surveys conducted in the case of assessee or money, bullion, jewelry or valuable article or thing or books of account or documents are seized or requisitioned in case of any other person. So deemed information, what is the meaning? Information, you know, 5 types. Deemed information, they are telling fine. There are 4 types of information. Deemed information means either there is a search under 132 or books of accounts or documents, assets, requisition 132A, or a survey is conducted under 133A other than your TDS TCS survey, or with prior approval of principal CAT or commissioner, money, bullion, jewelry or valuable article or books of accounts or documents are found in the case of any other person on or after 1st of April 21 which belongs to or pertains to or any information contained therein in respect of the assessee. But they are telling what? There should be books of accounts. There will be deemed to be information in the course of such search, such survey, search, you know, seizure. What information? In the case of assessee, where the search is initiated or survey is there, what has found? Books of accounts, documents, assets. These are the mantra there. Books of accounts, documents or assets or any other valuable article, money, bullion, jewelry, books of documents are seized or requisitioned in the case of any other person. Very simple. Then the third explanation is what? Specified authority would mean specified authority referred to in section 151. Now section 148A we have already discussed. Now 148A I will not go into detail, already we have discussed. Now 148B is okay. This prior approval for assessment, reassessment or recomputation certain cases. What is 148B? They are telling no order of assessment or reassessment shall be passed by an assessing officer below the rank of joint commissioner, except with the prior approval of the additional director, additional commissioner, joint director. 149. Section 149 is very important, my dear friends, my dear members. You have to analyze 149 for Finance Act 20, Finance Act 21, Finance Act 22. Basically 20 and 21. Why? This has a repercussion because we are going through the Supreme Court judgment now. So you understand 149, you understood Supreme Court judgment. So what is under the old act, my dear friends? Up to March 21. You know, earlier there were up to 4 years, beyond 4 years, up to 6 years. When you could reopen up to 6 years? When the income which has escaped assessment beyond 4 years up to 6 years was minimum 1 lakh rupees, or not fully disclosed, not fully and truly disclosed all material facts related to the assessment. Then you could have reopened the cases beyond 4 years up to 6 years. Then also there was one more situation, more than 4 years up to 6 years, beyond 6 years up to 16 years. In case of a resident in India having any asset abroad or any financial interest, including financial interest in asset abroad, and or income from any asset located abroad which is not disclosed here in India. So up to 16 years cases would have been reopened, but now that has shifted, pushed to Black Money Act. Therefore, in the new regime under 21, that section, that proviso is deleted. It is only now what? Earlier it was up to 4 years, beyond 4 years, up to 6 years, beyond 6 years, up to 16 years. Now it has become what? Welcome change. It is only up to 3 years. What was 4 years has become only 3 years, up to 3 years from the end of relevant assessment year, and beyond 3 years up to 10 years. So what has happened is 4 years became 3 years, but that 6 years has now been extended to 10 years. I will tell you the circumstances in which the department can go beyond 3 years up to 10 years. We will have an occasion to discuss. Now, so what is the new section 149(1) March 21? There was an amendment. March 21, there was an amendment. What is 149(1) they are telling now? No notice under 148 shall be issued for the relevant assessment year. A, 149(1)A, very important. If 3 years have elapsed from the end of relevant assessment year, unless the case falls under B. So A is what? 3 years have elapsed from the end of assessment year, unless the case falls under B. Come to B. If 3 years but not more than 10 years have elapsed from the end of assessment year, unless the assessing officer has in his possession books of account, document or evidence which reveal that income chargeable to tax represented in the form of asset which has escaped assessment amounts to or is likely to amount to 50 lakh rupees or more for that year. Then we will discuss, don't worry, go through the provision. Then there is first proviso, second proviso, third proviso, fourth proviso. And then there is one explanation. Now, we are in Finance Act 21, careful. So first proviso is telling, no notice under 148 shall be issued at any time in case of the relevant assessment year, beginning on or before 1st day of April 21. Please understand the law as it is. Very important, has a bearing on the Supreme Court judgment. No notice under 148 shall be issued at any time in case of relevant assessment year beginning on or before 1st day of April 21, if such notice could not have been issued at that time on account of being beyond the time limit specified under the provisions of B, clause B of subsection 1 of this section, as there should immediately before the commencement of Finance Act 21. We will see that. Second proviso says, provisions of the subsection shall not apply in a case where notice on 153A, C, read with 153 is required to be issued in relation to a search initiated on 132 or requisition 132A on or before the 31st day of March 21. Fine. Because after 31st March 21, my dear friend, this 153 ABC, etc., all merged into your reassessment regime. So they are telling 153 ABC notice cannot be issued. Fine. All notices will come only under 148, 148A, etc. Now, third proviso is telling, for computing the period of limitation as per this section, the time or extended time allowed to the assessee as per show cause notice under clause B of 148A, that's 7 days minimum or 30 days, etc., during which the proceeding under 148A is stayed by an order or injunction of the court shall be excluded. No problem. Fourth proviso is telling, after exclusion of the period referred to in the immediately preceding proviso, if the period of limitation or time available to assessing officer for passing an order 148A clause D is less than 7 days, such remaining period shall be extended to 7 days. And the period of limitation shall be deemed to be extended accordingly. So the problem here is now, what is this time limit for notice? You are telling me I can issue up to 3 years from the end of relevant assessment year. Okay. Beyond 3 years and up to 10 years from the end of assessment year. I cannot go beyond 3 years up to 10 years from the end of assessment year unless what? Assessing officer has to have in his possession books of accounts, documents or evidence. And that too, that should reveal, what should reveal? The books of accounts, documents or evidence. If I want to go beyond 3 years, I want to reopen a case beyond 3 years. The law is telling it's not that easy, my dear assessing officer. You cannot just reopen it. You should have in your possession books of accounts, documents, evidence. And that too, these 3 items should reveal the income which has escaped assessment, and that too, that should be only in the form of an asset. And that too, which has escaped assessment, amounts to 50 lakh rupees or more for that year. So I am not telling, sir, this is the law, Finance Act 21. So beyond 3 years, ask the question the assessing officer, hey, show me what is the books of account, what is the documents, what is the evidence. You are telling me books of account up to 10 years. Rule 6F, sub-rule 5 says you can't maintain, you need not maintain books beyond 6 years. Here you are telling me I have to maintain for 10 years, you can reopen for 10 years. Okay, under Companies Act, it is, 8 years. But Income Tax Act 44A, read with Rule 6F, sub-rule 5, says don't maintain the books beyond 6 years. Here you are telling me reopen up to beyond 3 years and up to 10 years. Fine. If I maintain the books of account, if I have kept the books of account, if he is able to get the books of accounts, then fine. Else he cannot reopen. Why? Because assessing officer should have in his possession either books or documents or any evidence. That too, from that, what should be revealed? It should be only an asset. And that too, that asset should be beyond 50 lakh rupees. Then only I can go beyond 3 years up to 10 years. That is Finance Act 21. I'm telling you, subject matter for discussion in the Supreme Court is only Finance Act 21. Then, moving further, what are they telling? First proviso, crystal clear, sir. 149A, first proviso, 149, subsection 1, clause A, clause B we discussed. Then come to proviso. First proviso is telling, no notice on 148 shall be issued at any time, beginning on or before 1st April 21. If such notice could not have been issued at that time on account of being beyond time limit specified under the provisions of clause B of subsection 1. That means what? Finance Act 21. Assessment year 13-14. What is the due date? Under the old regime, 6 years from the end of relevant assessment year, March 20. Again, for 15-16, what is the due date? Sorry, 14-15. 14-15 is March 20. 13-14, it is 20. 14-15, it is March 21. So up to March 21, I could have issued notice for only 15-16. I could not have issued for 13-14. 13-14 became time barred by March 20. 14-15 became, time barred by March 21. But for COVID, now when COVID struck in March 20, first understand the time limit under old regime 149. Yes, sir, 13-14, March 20, 14-15, March 21. Fine, sir. Now, COVID struck in March 20. Say, 20th of March 20. TOLA came into being, the Relaxation Act. Fine, sir. COVID is for you, COVID is for me, COVID is for department. No problem. So they extended, the TOLA came into being. So for 13-14, on 20th of March 20, for 5 years, 11 months, 20 days, you sat quietly, department. You sat quietly. What is my gross? You sat quietly for 5 years, 11 months, 20 days. Last 10 days delay was there. Okay, because of COVID, the Relaxation Act came. And the due date to issue notice for assessment year 13-14 is extended by 1.5 years to 30th of June 21. For 10 days delay, all right, because of COVID, you want 1.5 years? Anyway, then 14-15, you just come. 13-14, extended. Again, 14-15, March 21 was the due date. Extended up to 30th June 21. I have no problem, sir. TOLA is there, Relaxation Act is there, time limit is issued. But what has happened in the intervening period, my dear friends, on 28th of March 21, Finance Act 21 is passed. Assent given by the President of India, signed, it has become an act. And you, department, what you have done? Notification is issued. Excessive delegation. What has been done? Notifications were issued under TOLA, extending the due dates. Last 2 notifications only is the subject matter of discussion. The last 2 notifications which discuss the due date further, it pushed it beyond 31st March and up to 30th of June 21. That is 31st March 21. And again, 27th April 21. These 2 notifications, what you should have done? Notifications have come after the Finance Act 21 is passed. And in that notification, there is an explanation saying that the notice is issued under the old provisions of 147. What was not in existence, what was already dead, you made it alive only by virtue of a notification, excessive delegation. Parliament is there, legislature is there, act is passed. But you are telling, no, I am going to issue notice based on the 2 notification, as per which timeline is extended. I have forgotten the Finance Act 21. And under the 2 notifications dated, I am telling that old provisions of 147 will apply, and I am issuing notice under 148 under the old provisions. So this is the why 9 High Court judgments in India struck down this provision, saying that it is illegal, void ab initio, ultra wires the act, except for, Palak Katuja's case, single bench judgment of Chhattisgarh bench. Anyway. So now we move further. This is just a background coming back. Now we move further. Now, Finance Act 22, what is the limit now again? It is same thing, sir. 3 years from the end of relevant assessment year. Now, what has been done? Finance Act 22 also, I'm telling you, beyond 3 years, up to 10 years, no problem. Same thing, it continues, books of accounts, document, evidence. But now they came to know all their mistakes, department. Earlier, what they told? Up to 3 years, beyond 3 years, up to 10 years, asset should be there, which reveals that income has escaped assessment. And that asset also, they told only 4 types of assets: land and building, shares and securities, loans and advances, and bank deposits. Clearly, meaning of asset is given. Asset shall include. Now, what they have done, sir? Earlier, they told only asset. Now, they are telling the new limit, Finance Act 22. They are telling same thing: books of account, possession, document, evidence, etc., which reveal that income chargeable tax represented in the form of asset, comma, expenditure. Not only asset, they say expenditure in respect of a transaction or in relation to any event or occasion, or entries or entry in books of accounts. What is it? What entry? It may be a debit entry, it may be credit entry, it may be journal entry. What a dangerous provision, sir. They are only telling entries in books of account. So asset, expenditure is in respect of a transaction or in relation to an event or occasion, or entry or entries in books of account. Then that continues, same thing, which has escaped assessment, amounts are likely to amount to 50 lakh rupees or more. What is the difference? Please understand the difference. In Finance Act 21, 50 lakhs was for per assessment year. Now they are telling 50 lakhs is in aggregate. The department has realized the mistake and made a retrospective amendment. I don't know, we don't know. There will be a controversies here, Finance Act. But Supreme Court is telling Finance Act 21. Finance Act 22 has made this amendment now. No more only asset, it is asset, expenditure, or entry in books. And that income which has escaped assessment is 50 lakh rupees or more, but it's in aggregate. Whereas in Finance Act 21, it was per annum and only asset. And there are only 4 types of asset: land and building, loans and advances, bank deposits, and your shares and securities. So that definition continues, sir. That definition still continues. So, but this is the difference in Finance Act 22, Finance Act 21. Anyway, we move forward. Now there is one proviso in 149(1) Finance Act 22. Very, very important proviso. They are telling, provided no notice under 148 shall be issued at any time in case for a relevant assessment year, beginning on or before 1st day of April 21. Clearly, proviso is telling, sir, bracket, what is this? Is the addition. Notice under 148 of section 153 AC could not have been issued at that time on account of being beyond the time limit specified under provisions of clause B of subsection 1 of this section, or 153 or section 153C, as the case may be, as they stood immediately before the commencement of Finance Act 21. My dear friends, earlier also you could go beyond 10 years, beyond 6 years, up to 10 years. When? Only under 153C cases, 153A cases. You remember that department, now they made an amendment there, 153A and C, you could go beyond 6 years, up to 10 years. When? Same thing. You know, the income which has escaped assessment more than 50 lakhs. So that is also there now. Next, provided further provisions of subsection shall not apply in a case. This is the same thing, where notice on 153A or C read with 153A required to be issued in relation to, you know, the search initiated under 132 or books of accounts, documents, etc. Moving further, now 1A is inserted. Very much clear. It says, notwithstanding anything contained in subsection 1 where the income chargeable to tax represented in the form of asset or expenditure, etc. It does not talk about books of entry, that entry in books. It only says form of asset or expenditure relation to event or occasion has escaped assessment, and investment in such asset or expenditure is more than relating to is more than in more than one previous year within the period referred to in clause B of subsection 1. Notice on 148 shall be issued for every such assessment year. No problem. Every year we are going to issue, and that 50 lakhs limit we have to see in aggregate. Now 151 is very simple section. Only there are, you know, up to 3 years is only principal, commissioner or director. Beyond 3 years, you have to take principal, chief commissioner. That's all. 151A is your faceless assessment of income escaping assessment. Now, moving further, 135A is faceless collection of information. Now come to this board circular also. They are giving the meaning of information in accordance with risk management strategy. Don't tell me that there is what is risk management strategy is not given already. You know, board has come out with a clarification for reopening of all 15, 16, 18, 19 cases on 10th of December 21. Clearly, no, the department, you remember March 22, they were reopening cases of 15, 16. Why? Because 6 years. And why 18, 19? Because 3 years. So 3 years from the end of assessment year, no limit. It is not less than 50 lakhs, my dear friends. No, there is no limit. It may be less than 50 lakhs or more than 50 lakhs. Up to 3 years, there is no limit. Beyond 3 years, that was 50 lakhs. That is why department, you would have seen a flurry of notices in March 22 for 15, 16, 3 years, I mean 6 years. and for 18-19, 3 years. That period was expiring. That is why they had issued a lot of notices. Anyway, so here this board circular is also giving the meaning of this information, RMS. What is RMS? So here, this is uploaded on verification report. You need to upload a functionality on Insight portal. Information from government agency, law enforcement agency, information arising out of internal audit objection requires action 148, received from income tax authority, including assessing officer, then arising out of search or survey, FTTR references, all these non-resident cases, arising out of any order, appellate order, NCLT 263, 264, etc. Cases involving addition in any assessment year on recurring issue of law or fact exceeding 25 lakhs in metro cities at Ahmedabad, Bangalore, Chennai, etc. And other charges, quantum of addition should exceed 10 lakhs, exceeding 10 lakhs or more in transfer pricing, etc. So all this is already given. But here, my dear friends, I am questioning that because when I go to Supreme Court judgment, here it is already given in the board circular. This instruction issued by board. Para 5, very, very important. Mark that and prepare defense in on your replies now, whenever you receive notice now. Clearly, they say para 5 of this board circular, as per provisions of 149 1B in specific cases, where the assessing officer has in his possession evidence which reveal that income escaping assessment represented in the form of asset, etc. Because Finance Act 21 only. Amounts to or likely to amount to 50 lakh rupees or more. Notice can be issued beyond period of 3 years, but not beyond period of 10 years from the end of assessment year. Further, I am not telling, see that board circular, it is clear. Further, the notice under 148 cannot be issued at any time in case for the relevant assessment year beginning on or before 1st day of April 21, if such notice could not have been issued at that time on account of being beyond the time limit prescribed under provisions of B, as they stood immediately before the proposed amendment. So March 21, you could not have issued for 13-14 and 14-15. Matrons only could have issued for 15-16. And again, they are telling as per what could not have been done then also cannot be done now. As per explanation provided to section 149, term asset shall include immovable property being land or building or both, share securities, loans, advances, deposits in bank. Fine. Now this also I am telling you, taking you to the one high court judgment. There are 9 high court judgments obviously. Rajasthan High Court judgment, Sudesh Taneja, writ petition, delivered on 27 January 22. Why I am taking you to this judgment is to see the meaning of 149. How to read 149. So what are they telling? Under no circumstances, the extended period available in Clause B of 149(1), which we may recall now stands at 10 years instead of 6 years, which are available with revenue, can be pressed in service for reopening assessments for past period. This flows from the plain meaning of first proviso to subsection 1 of 149. In plain terms, a notice which had become time barred prior to 1421, prior to 1421, the 13, 14, 14, 15 became time barred. As per the then prevailing provisions, would not be revived now, forget Tola, would not be revived by virtue of application of section 149 1B, effective from 1421. All the notices issued in the present cases are after 1st April 21. What is the subject matter of dispute in Supreme Court? Notices issued from 1/4/21 to 30th June 21, and that too it is for 13-14, 14-15, 15-16, 16-17, 17-18. We will discuss now. All the present notices in the present cases are after 1st April 21 have been issued without following procedure contained in 148A and therefore invalid. Anyway, so that 149(1) beautifully the court has discussed. Now our own High Court of Karnataka, Mohammad Mustafa's case, judgment delivered on 18th April 22. Clearly they are telling reassessment notice issued on or after 1st April 21 should comply with new provisions as substituted by Finance Act 21, as the old reassessment provisions were repealed and substituted by new provisions sans any savings clause. There is one new point, savings clause. There was no savings clause at all. A. Shankar argued very beautifully here by stating that where is the savings clause here? There is no savings clause at all in the new provisions. So notice issued on or 1st April 21 should comply with the new provisions as substituted by Finance Act 21, as the old reassessment provisions were repealed. Finance Act was passed, sir, and substituted by new provisions sans any savings clause, etc. So this is what they are telling, that notification 20/21 issued on dated 31st March 21. These two notifications only. And one more is notification 38/21 dated 27th April 21. Which was issued by central government and 3(1) of the Relaxation Act 2021. Now we come to the Supreme Court judgment delivered in the case of Ashish Agarwal versus Union of India, civil appeal number 3005/2022, delivered on 4th of May. My Lords Justice M.R. Shah and my Lords Justice B.V. Nagratna. So this order is of 34 pages, having round about 12 paragraphs. We'll discuss para by para to have a brief understanding. Now what is para 1 to 3? this page 1 to 3, basically it's giving the details of all the civil appeal number and the civil appeal number arising out of all the SLPs, etc. Nothing to worry. Next, para 1, page 4. Now we go to page 4, para 1. See the para, what are they telling? This, you are aggrieved. Now the department, let me tell you, SLP is preferred against not all the High Court orders, only against the order passed by High Court of Allahabad. That's all. So SLP is preferred by the department against the High Court order passed by Allahabad, obviously quashing that 148 notice issued under the old regime. Okay. So because of this, this is in Supreme Court. Next. And you know, the several high courts also had allowed the writ petitions and quashed several reassessment notices issued by revenue on the ground that the same are bad in law in view of the amendment made by Finance Act 21, which has amended Income Tax Act by introducing new provisions, that is section 147 to 151. So, you know, what was, therefore, revenue has presented, they prefer this appeal. Very simple, sir. March 21, there is an amendment. You are issuing notice in 1st of April 21. That means what? You should follow the sum and substance. You have to follow the dictum of 148A. Before issuing 148, you should follow the steps of 148A, B, C, D. Do inquiry, give show cause notice, give an opportunity to the assessee, collect the reply, when consider the reply of the appellant or the assessee, and then consider the material available on record, pass an order 148A-D, along with that issue notice on 148, which the department did not do. They continued to issue notice under 148, even though the Finance Act is amended there. Finance Act is passed. So between 1st April 21 to 30th June 21, there are two regimes now. Two Finance Acts are operating. One is the old regime, Finance Act 21. One is the new regime, Finance Act 21, Finance Act 20. Two schemes are operating. Is it possible? No. So now then we go to para 2, page number 4. Para by para we are taking. In page 4, they are giving all the judgments, sir. They are giving the judgment of High Court of Delhi, High Court of Rajasthan, High Court of Calcutta, Chennai, Bombay, etc. So Ashok Kumar Agarwal, you know, that is the Allahabad High Court. And then Manmohan Kohli, Delhi High Court, very famous judgment again. So all these judgments, Sudesh Chaneja, Rajasthan High Court, WIT, that is Vellore Institute of Technology, Madras High Court. One more landmark judgment, Tata Communication Transformation Services, Bombay High Court, also relied on by Mohammad Mustafa's case in Bangalore. Our Bangalore, you know, the Karnataka High Court judgment is not there, probably because the order was not released, I think, on that day. Else they have mentioned all the other orders. Now move forward. Now when you move forward to this page number 7, para 2.1. Page number 7, para 2.1. Our learned ESG, that is Additional Solicitor General Venkatraman, he is stating at the bar that revenue is now going to file appeals against the similar judgments and orders passed by all other various high courts. But you know, because the issue is common and because of the multiplicity of the proceedings and to lessen the burden of this court, we now propose to pass an order in exercise of powers under Article 142 of the Constitution of India. Now the Supreme Court is exercising its powers under Article 142 of Constitution of India. Normally 142 is exercised in, you know, not in these economic offences cases. You know, it was exercised, for example, in the Ayodhya case, Ram Janambhoomi, where around 2.17 acres land was given to the temple trust and 5 acres was given to the mosque, example. And, you know, again, it was exercised Article 142 in Union Carbide case, you know, the Bhopal gas victims in order to give compensation. Or, you know, again, your coal block cases, etc. So all these judgments are there anyway. Now they are telling Supreme Court, I am going to exercise Article 142, which will govern all other judgments and orders passed by various high courts, so that the revenue need not file separate individual appeal, which will be more than 9,000 in numbers. 9,000 appeals. There is a figure given by Venkatraman, learned Additional Solicitor General. He is telling 9,000 writs have already been filed. Now, then at the para 3.1, page 13, they are discussing, you know, the power vested under 3 of the TOLA, Relaxation Act, that notifications. So we told you that those notifications, which extended the limitation for issue of notice. Then, para 3.1, you know, they are giving the explanation to notification dated 31st March 21 and 27th April 21, etc. under Section 3 of Relaxation Act, which stipulated that the provisions as they existed prior to amendment by Finance Act 21. Understand, only those two notifications, that is notification dated 31st of March 21 and notification dated 27th April 21. Now you are telling me when you are issuing notice under the old regime under 148, 147, you are telling me when Finance Act 21 is passed, I am issuing under the old regime. And they are telling these notifications shall apply to reassessment proceedings. That is why they were quashed. Then para 3.2, page number 14 to 19, you know, they are giving the verbatim reproduction of all the substituted sections 147 to 151. which are effect from 1st of April 20. Provisions of 150 as the reassessment notices issued on or after 1st of April 21 are governed by the substituted sections 147 to 151 of the Act. Now, consequently, what has happened? All the respective high courts have set aside the reassessment notices wherever it is assailed. Now, however, the High Court of Delhi, in its judgment dated 15/12/21, while quashing the respective reassessment notices, also observed that if the law permits the revenue to take further steps in the matter, they shall be at liberty to do so. Now, para number 6, they are telling what Supreme Court is telling: radical reformative changes are made governing the procedure for reassessment proceedings. They themselves are telling Finance Act 21, radical reformative changes are made. Earlier, what was there, gave rise to numerous litigation, old provisions on various grounds, reason to believe, etc. Your Kelvinator's case, no tangible, reliable material information in possession of assessing officer, leading to formation of belief that income escaped assessment, Lakshmani Meval Das, no inquiry being conducted by assessing officer prior to issuance of notice, reopening based on change of opinion, etc. And so many judgments were there. Yes, Narayanappa, etc. It cannot be a pretense, it cannot be subjective, etc. And then your GK and drive shaft, etc. Now, and in some cases beyond also. It is a Supreme telling Parliament thought it fit to amend the Act to simplify tax administration, ease compliances, reduce litigation. I am sorry, the litigation. Simplify. Why are the amendments made to Finance Act 21? Simplify tax administration, ease compliances, reduce litigation. So there is no question, no chance of reduction in litigation. In fact, the litigation is going to multiply now. So therefore, they are telling this is in a view to achieve this object by Finance Act 21, 147 to 149, 151 have been substituted. Now, then they are giving the explanation for the new Finance Act 21, which we studied everybody, 148A, etc. Now, what is the Supreme Court telling? 148A shall be a game changer with an aim to achieve ultimate object of simplifying the tax administration, ease compliance, and reduce litigation. Now, moving forward, they are giving the meaning of 148, etc. I told you, discussing everything. Move forward now. Now, very important, para 6.6, page 25, substituted section of 149 has reduced the permissible time limit for issuance of notice to 3 years, and in exceptional cases, 10 years. It also provides further additional safeguards which were absent under earlier regime pre-Finance Act 21. Supreme Court is clearly telling, sir, additional safeguards which were absent under earlier regime pre-Finance Act 21. Thus, the new provision substituted by Finance Act 21 being remedial, benevolent in nature. Now, Supreme Court is telling the new Finance Act 21, these provisions are remedial, benevolent in nature, substituted with a specific aim and object to protect the rights and interest of the assessee, as well as the same being in public interest. So the benefit of new provisions shall be made available even in respect of proceedings relating to past assessment years, provided Section 148 notice has been on after 1st April 21. No problems. So the crux, the subject matter of this Supreme Court is telling, we are in complete agreement with the view taken by various high courts in holdings. So, however, time judgments of several high courts would result in no reassessment proceedings. If the same are permissible, even if the same are permissible under Finance Act 21 and as per substituted sections 147 to 151, Supreme Court is telling revenue cannot be made remediless and object and purpose of reassessment proceedings cannot be frustrated. Then they are telling it is true that due to bona fide mistake and in view of subsequent extension of time, wide various notifications, impugned notices under 148 after the amendment was enforced with effect from 1/4/21 under the unamended Act 148. Then Supreme Court is telling, in our view, the same ought not to have been issued under unamended Act and ought to have been issued under substituted provisions of 147 to 151 as per Finance Act 21. So Supreme Court has agreed. You should not have issued notice under the unamended Act, but you should have ought to have issued under the substituted provisions of 147 to 151. But Supreme Court is also telling revenue cannot be made remediless. Object and purpose of reassessment proceeding cannot be frustrated. It is a bona fide mistake. Here I will not agree, sir, with the Honorable Supreme Court. Bona fide mistake. 90,000 notices issued by 90,000 officers all over India, and none of them followed the new regime. None of them knew what is the amendment. None of them knew that Finance Act 21, it was already amendment is in place. Finance Act 21 is passed. All 90,000 officers, all 90,000 notices have issued notice under the old regime, relying only on the two notifications dated 31st of March and 27th April. And that too, you're issuing notice under 148 or 147 under the old regime. 90,000 notices by 90,000 officers, etc. And you're telling it's a bona fide mistake? Anyway, that is the things to ponder. Now move forward. Again, Supreme Court is telling there appears to be genuine non-application of amendments as the officers of the revenue may have been under bona fide belief that the amendments may not yet have been enforced. I don't understand, sir. From 1st of April to 30th of June, 1st of April is what? Before that itself, the Finance Act was passed. How can you ever issue notices under the old regime? And here the Supreme Court is telling that they may have been under bona fide belief that amendments may not yet have been enforced. Act is passed, sir, already. Anyway, now therefore, Supreme Court is again telling we are of the opinion some leeway must be shown in that regard, which the High Courts could have done so. Therefore, instead of quashing and setting aside the reassessment notices, High Courts ought to have passed an order construing the notices under unamended provision of the IT Act as those deemed to have been issued under 148A. So Supreme Court is telling whatever notices issued on 148, High Court should have deemed to construe that notices is issued under 148AB of the Act under the new provisions. And revenue ought to have been permitted to proceed further as per substituted provisions of 147 to 151, subject to compliance of all procedural requirements and defenses which may be available to the assessee under the substituted provisions of 147 to 151 of the Act, which may be available under Finance Act 21 and in law. Therefore, now we propose to modify the judgments and orders passed by respective High Courts as under. Now, what is the Supreme Court telling? The respective impugned Section 148 notices issued shall be deemed to have been issued under 148AB. So, whatever notices issued under 148 between 1st of April 21 to 30th of June 21 shall be deemed to have been issued under 148AB of the Act as substituted by Finance Act 21, and it will be treated as a show cause notice 148AB. Then Supreme Court is telling all the assessing officers shall within 30 days from today, the date of judgment, that is 4th of May. From today, you have to give the information and material relied upon by revenue so that the assessees can reply to the notices within 2 weeks thereafter. So Supreme Court is telling first consider 148 to be issued as 148AB, which is show cause to the assessee. Thereafter, all the assessing officer within 30 days from the date of order 4th of May, that is maybe within 3rd of June, 1 month I am giving you, kindly please give the material and please give the information which is relied upon by the revenue. Thereafter, the assessee would get 14 days time, 2 weeks time to reply to the notices. Then, the requirement of conducting any inquiry with the prior approval of specified authority and 148A be dispensed with as a one-time measure. You know 148A how it starts? Conduct inquiry if required. So that Supreme Court is saying I will dispense with that as a one-time measure. Vis-a-vis those notices which have been issued under 148 of the unamended Act from 1st of April 21 till date, including those which have been quashed by the High Courts. Then, number 3, the assessing officer shall thereafter pass an order in terms of Section 148AD, fine, after following due procedure on 148AB in respect of each of the concerned assessees. Then, 4th one, very important, all the defenses which may be available to the assessee under 149, Supreme Court is telling, sir, all the defenses which are available to the assessee under 149 or which may be available under Finance Act 21 and in law, and wherever rights are available to assessing officer under Finance Act 21 are kept open or shall continue to be available. So at one point of time when you go through Supreme Court, you read once, you read twice, you read thrice. You may be of the opinion, oh, this is, totally stashed or totally, in favor of the revenue. No. This sentence, the Supreme Court is telling all defenses which may be available to the assessee under Section 149 and which may be available under Finance Act 21 and in law. See, for assessee, what are they telling? Under Finance Act 21 and in law. Whereas for assessing officer, what are they telling? Rights are available to AO under Finance Act 21 are kept open and shall be available. Then, the present order shall substitute, modify respective judgments and orders passed by respective high courts, quashing similar notices issued under unamended section 148 of the Act, irrespective of whether they have been assailed before this court or not, whether you have filed writ petition or not. It is no problem. All 90,000 notices are now quashed. So litigation will start. All 90,000 notices, which have been issued under 148 under old regime shall now be deemed to have been issued under 148A Clause B. Within 30 days, what Supreme Court is telling, within 30 days from today, that is 4th of February, on the day I have delivered this judgment, kindly give the information and material which the revenue has relied upon to the assessee so that he can file his objections. Thereafter, within 14 days, assessee has to file his objections, etc. And then the assessing officer has to pass an order 148A Clause D, saying that whether it's a fit case for assessment or it's not a fit case for reassessment. Moving further. Para 9, page number 29 to 31, there is a broad consensus on the aforesaid aspects among the learned ASG appearing on behalf of revenue and learned senior advocates, learned counsel appearing on behalf of respective assessees. What do you mean by broad consensus, sir? Can you agree or can you have a consensus on behalf of all 90,000 notices, 90,000 assessees? You are telling me I will have a broad consensus on the aforesaid aspects. How can you decide amongst yourself? Amongst the learned ASG appearing on behalf of revenue and learned senior advocates, learned counsel, etc., appearing on behalf of respective assessees. What about the other assessees? On behalf of them, you are taking broad consensus? Anyway. So we are also of the opinion that if the aforesaid order is passed, it will strike a balance between the rights of revenue as well as the respective assessees, as because of a bona fide belief of the officers of revenue in issuing approximately 90,000 such notices, the revenue may not suffer, as ultimately it is the public exchequer which would suffer. That we agree. Now, therefore, we have to propose to pass the present order with a view to avoiding filing of further appeals before this court. Burden this court with approximately 9,000 appeals, because 9,000 writs are anyway filed. Again, similar judgment. Everything has to reach Supreme Court. Department is going to file an SLP. And orders passed by various high courts. Therefore, Supreme Court is telling, I am now invoking my power under Article 142 of the Constitution by holding that the present order, only one order, this against Allahabad High Court, this is, shall govern not only the impugned judgment orders passed by High Court of Judicature at Allahabad, shall also be made applicable in respect of similar judgments and orders passed by various high courts across the country. And therefore, the present order shall be applicable pan-India, crystal clear. Therefore, at the end in para 10, page number 31 to 33, Supreme Court is saying that the present appeal is allowed in part, and all the orders which are passed by High Court and other allied tax appeals are hereby modified and substituted as under. Very simple. So we read that. First one is what? That 148A shall be deemed to be issued under 148AB, and it shall be construed to be a show cause notice. Again, within 30 days, you have to give the assessing officer as to provide the information, material relied upon by the revenue, and assessees can reply to the show cause notice within 2 weeks thereafter. Number 2, these are all the now at the end. What is the direction given by Supreme Court? Now, at 2, requirement of conducting any inquiry dispensed with approval of your obviously specified authority under 148A is now dispensed with as a one-time measure vis-a-vis those notices which have been issued under 148 of the unamended Act from 1421 till date, including those which have been quashed by high courts. Next 3. Then assessing officer shall pass orders in terms of 148 AD by following the procedure. Then number 4, all defenses available to the assessee under 149 of the Act. Clearly, Supreme Court is telling all defenses available to assessee under 149 and all rights and contentions which may be available to concerned assessees and revenue under Finance Act 21 and in law shall continue to be available. Para number 11, page 33 to 34. Present order shall be applicable pan-India. All judgments, all orders passed by different high courts on the issue and under which similar notices were issued on or after 1st April 21, issued under 148 of the Act shall be set aside. Now 90,000 notices will again come, sir. 90,000 notices already issued, example. So you are going to receive 148 AB within 30 days. Now the problem, practical problem, let me tell you. 90,000 notices were issued. Few of them, you would have filed writ petitions in the high courts. That's what they told, 99,000 writs. Few of them, you are going to object before the assessing officers. 148 is issued, you will file your objections. Few of them, you would have filed the return under 148, etc. Few of them, orders are also passed. That will be very rare. Orders may be passed. Against the order, you would have filed appeal, etc. Now, the problem, therefore, is 90,000 notices are issued by assessing officers all over India. And now they are telling, I am setting aside all the 90,000 notices as what? Those 148 notices have now become what? Deemed to be have issued under 148AB. Very good. So all 90,000 notices under 148 under the old act. It was mostly for, because from 1st of April to 30th June, 90,000 notices. Maybe, 70-80% will be only for 13, 14, 14, 15. Rest maybe for 15, 16, 16, 17, 17. So the problem now is when 148 was issued, I objected to the notice. I filed return because it was an old regime. I filed return declaring the same income which was declared under 139.1 or 139.4 or 139.3, etc. And I would have asked for copies of reasons recorded, etc. So I would have filed return. And department would have also given me the reasons recorded. I would have, filed my objections. Now the problem therefore is after I filed the objections, the department transferred the case to faceless assessment. Now all the cases have to be recalled from the faceless assessment now. All these cases, what has happened. The JAO, practically what was happening, jurisdiction assessing officer issued 148 notice. You filed your objections, you filed the return. After you filed the return, you ask copies of reasons recorded. Department give you copies of reasons recorded. You filed your objections. Moment you file objections, the assessing officer, the jurisdiction assessing officer, transfer the case to faceless assessment. So now the department has to get all the, again, records back from faceless assessment. You have to get the records from faceless assessment. And now I think they cannot issue a notice again because that 148, Supreme Court is telling 148 notice issued shall be deemed to have been passed on 148AB. So 140, probably they'll send a letter now along with that notice again. And along with what they're telling, Supreme Court is telling, provide all the material, provide all the information based on which you had reopened the case. So that will come to me within period of 1 month. They have to send all that letters, notice, etc. material. Based on that, again, litigation starts. Now, when I'm going to see that information, that information suggesting income as escaped assessment, because now Supreme Court is telling, follow the new regime. You issued under 148. So reason to believe what they issued, reason to believe 148 now becomes information suggesting that income chargeable to escaped assessment. So now you don't tinker, tamper with the reasons to believe. Department cannot tinker or tamper with the reason to believe. You are now, what I am telling, 148AB, you are giving me the information material. What was that earlier reason to believe will now become information suggesting income as escaped assessment. Because Supreme Court is telling follow the new law. So what was reason to believe became information. You cannot tinker, tamper, change, alter, delete, amend that information. What was reason to believe? Same information you have to give me as it is. And then I am going to file my objections, etc. 148 AD, 14 days time you have given me. There also I am going to argue. The section itself says you are giving me 30 days time, minimum 7 days time, maximum 30 days time to file reply. And in fact, even what is the section is telling, based on an application by the SSC, the time limit can further be extended. But Supreme Court is telling, I am giving you 14 days time. So in my opinion, that may not be correct. I will go as per the section, and beyond 14 days also I may go up to 30 days. Section is giving me the time. Even I can go for extended time limit also, based on an application. Anyway. So here I will object, sir. And again, when you give me this information, if you are following Finance Act 21, only 2 types of information, sir. What are the 2 types of information? RMS strategy, flagged information flagged by RMS strategy formulated by board, risk management strategy formulated by board. Second one says what? Audit objection of CAG, C&AG. Only 2 types of information, Finance Act 21. So if that information is other than these 2, I am going to file my objections. So this is the way you have to prepare yourself now. Anyway, 90,000 notices are quashed, set aside. Now they have all become 148AB. Be careful now. Because 4th May order was passed. Today already, I think, what is the date, sir, today? 12th of May. 12th of May. So that much time has gone. Nobody has issued till now. Nobody has received 148 AB. Probably another 10 days it may take. I told you all the data has to come from faceless assessment. Again, you have to give me departments clear telling within 30 days, give them material and give them 14 days time. So department will not give you, sir, on last 1 week before only they are going to give you because they have 1 month time. So probably on the 25th day, say May 25th or May 26th, etc., it may release this material and this. Then you start filing your objections. Please see to it that what is information. It is no more reason to believe. You earlier gave me reason to believe. Now it is what? It has become information. Reason to believe has changed now. It has become information. What is the meaning of information? Under Finance Act, only 2 types of information. Please file the objection. Again, what about 149, sir? You are telling me new regime? When I come to new regime 149, it's only up to 3 years, beyond 3 years, up to 10 years. Up to 3 years from the end of assessment year. Beyond 1920, I cannot go. Anyway, this is 13, 14, 14, 15. So because of 149, what could not have been done then cannot also be done now. In my humble opinion, it would be time barred. Anyway, we are going to see yesterday the instruction has come, board instruction also, board circular. Let us see, what is the stand of the department. So this is the Supreme Court order. We will see this. Now move forward. So binding observations we discussed in detail. All these directions Supreme Court we discussed. Yesterday I am telling you the movement 4th of May, Supreme Court has passed the order. Bombay High Court has immediately, disposed of all the petition challenging 148 notices as per Supreme Court ruling. They have quashed everything. They are telling now you follow the Supreme Court order. Immediately they quashed all the notices. And if you see one notice I just downloaded here, Dhruv Cheda's case, what are they telling? Simple. Honorable Apex Court in paragraph 10 passed the following directions. That paragraph 10 we saw 5 points. In view of the above and for reasons stated above, appeals are allowed in part. Impugned common judgments, orders passed by High Court, etc. is hereby modified, substituted as under. So impugned section 148 notices issued to respective which were issued under 148 subject matter of writ petition shall be deemed to have issued under 148 AB, etc. Construed show cause notice, etc. So everything they are following that, and then they are telling, in view of the above petitions disposed, certainly since all rights and contentions of parties open, assessing may take such steps if they are agreed by the any order passed by assessing officer. In view of the above, wherever assessment order has been passed, those assessment orders will stand quashed and set aside. So also consequential orders and notices. Revenue may restart the process. Please see this. Revenue may restart the process as directed by Supreme Court. Entire process is being started again. Revenue may restart the process as directed by Honorable Supreme Court. Again, litigation started for 90,000 cases. Now, yesterday instruction has come 11th of May 2022. Even this instruction, what is the board instruction? What are they telling? Please come to this relevant para. Scope of the judgment. Para 5. Scope of the judgment. Now, para 3, if you see, Honorable Supreme Court has held that these extended reassessment notices issued under old law shall be deemed to be show cause notice and 148 AB. No problem, sir. I have no problem of the new law and has directed AO to follow the procedure with respect to such notices. It is also held that defenses available to assessee and 149 of the new law and whatever rights are available to the assessing officer under the new law shall continue to be available. Honorable Supreme Court has passed this order in excess of its power on Article 142. Absolutely no problem, sir. Now come to para 5. Taking into account decision of Honorable Supreme Court in various paragraphs, clarified that the judgment applies to all cases where extended reassessment notices have been issued, that is from 1st of April to 30th of June. This is irrespective of the fact whether or not such notices have been challenged or not. Now, para 6, very important. Operation of new section 149 of the Act to identify cases where fresh notice under 148 Act can be issued. So, with respect to operation of new section 149 of the Act, following may be seen. This department is, telling. Honorable Supreme Court has held that the new law shall operate and all defenses available to assessees under 149 of new law and whatever rights are available to AO under the new law shall continue to be available. Then they are giving that 149 of the Act before its amendment by Finance Act 22. That is up to 3 years, beyond 3 years, up to 10 years, etc. Because Finance Act 21 only, that, asset, reveal that income escaped assessment, asset 50 lakhs or above, that's all. So then Honorable Supreme Court has upheld the views of High Courts that the benefit of new law shall be made available even in respect of proceedings relating to past assessment years. Fair enough. Decision of Honorable Supreme Court read with the time extension provided by TOLA will allow extended reassessment notices to travel back in time to their original date when such notices were to be issued, and then new section 149 of the Act is to be applied at that point? I don't agree, sir. I don't at all agree with this. What is the board telling here? Decision of Honorable Supreme Court read with the time extension provided by TOLA will allow extended reassessment notice travel back in time to their original date when such notices were to be issued, and then new section 149 is to apply at that point of time. Now, based on the above, extended reassessment notices are to be dealt with as follows. Board is giving this SOP note to their officers. They are telling deal as follows. First, for 13, 14, 14, 15, 15, 16. Fresh notice under 148 can be issued in these cases with approval of specified authority only if the case falls under Clause B of subsection 1 of 149 as amended by Finance Act 21. What is Clause B, sir? Beyond 3 years up to 10 years. So they are telling if it is beyond 3 years up to 10 years for 13, 14, 14, 15, 15, 16, that too beyond 3 years up to 10 years means what? Asset, income escaping assessment, which reveals should be only in form of asset, 4 types of asset, etc. And the income which is escaping assessment should be 50 lakhs or above. This is what the board is telling. Then only you can reopen. Only if the case falls under Clause B of subsection 1 of 149. For 13, 14, 14, 15, if at all now 90,000 notices are issued, what is this board telling first? They are telling in this instruction that suppose there should be an asset and it's more than 50 lakhs and only 4 types of asset, etc. That too should be beyond 3 years up to 10 years. So if there is no asset meaning is given only 4 assets. Suppose you are issuing for penny stock now. Penny stock you are reopening. Suppose 43B, GST payable, etc. 40IA, non-deduction remittance of TDS, etc. Late remittance, etc. 40A1 in case of non-residence, etc. So all these, it cannot reopen because where is the asset? Even penny stock, if they are going to tell I sold the penny stock shares, I invested in a property example, then that asset, because penny stock is found to be bogus, the board may, the officer will contend that that asset which is generated out of sales of penny stock. Anyway, these are all, litigative aspects. So what are they telling? Board is telling 13, 14, 15, fresh notice under section 148 can be issued in these cases with approval of specified authority only if the case falls under B as amended by Finance Act 21 and reproduced in paragraph 6.1 above, specified authority 151. Okay. Then 16, 17, 17, 18, they are telling fresh notice under 148 can be issued in these cases with the approval of specified authority under Clause A. Clause A was 3 years from the end of assessment year. If 3 years from the end of assessment year, how can you issue, sir, for 16, 17, 17, 18? They are telling fresh notice under 148 can be issued in these cases with the approval of specified authority under Clause A of subsection 1 of new section 149, since they are within the period of 3 years from the end of relevant assessment year. How can it be, sir, from Finance Act 21? Because of TOLA. Very cleverly, the board, they have applied TOLA, which has given extension of time limit. They applied TOLA such that it became 3 years from the end of assessment year, Finance Act 21. But will the statute allow? Earlier in March 22, they told 3 years from the end of assessment year, 18, 19 was allowed and 6 years is 15, 16. So that 149.1 is crystal clear. Finance Act 21, you could not have issued notice for 13, 14 and 14, 15 because the time limit had expired standing as on the date. So 13, 14, 14, 15 date had expired, sir. You could not have issued notice 6 years from the end of relevant assessment year prior to Finance Act 21. And even 16, 17, 17, 18, only what you could have issued is 15, 16. 16, 17, 17, 18 also, it is not 3 years from the end of relevant assessment year. Because of TOLA, they have extended that 1.5 years time limit. Now the board is saying you can issue karke. Now, then cases where assessing officer are required to provide information and material relied upon within 30 days, very important. Now they are telling for what cases I am going to give you information. So board is telling Honorable Supreme Court has directed that all information material required to be provided in all cases within 30 days fine. However, it has also been noticed that notices cannot be issued in a case for 13, 14, 15. If the income escaping assessment in that case for their amounts are likely to amount less than 50 lakhs, at least that much they agreed. So 13, 14, 15 board is telling you can't issue notice at all if the income escaping assessment in that year amounts are likely to amount to less than 50 lakhs. First of all, I am of the opinion, that emphatic opinion, sir, that you cannot issue notice for 13, 14, 14, 15 at all. Because 149, 1A, Finance Act 21 is crystal clear. 13, 14, 14, 15, you could not have issued then. What could not have been done then? You cannot do it now. Definitely, reassessment, the time was extended. We have no grounds against the time limit. Time was extended up 30th June. But for issuing those notices, you should have followed the dictum of 148 and 148A of the new regime, etc. Now, no problem. 13, 14, 14, 15, what the board is telling, at least now they are some part of the issue has attained finally. They are telling if it is more than 50 lakhs only, you please go for reopening. Not more than 50 lakhs, kindly do not issue notice at all. Hence, in order to reduce the compliance burden of associates, out of 90,000 notices, in my opinion, I think around about 50% may go. Because 13, 14, 14, 15, 15, 16 only. 13, 14, 14, 15, they are telling not more than 50 lakhs, it goes. They are telling don't at all issue notice for, this 148. Hence, in order to reduce compliance burden of associates, clarified that the information and material may not be provided in a case for 13, 14 and 15 if the income escaping assessment is less than 50 lakh rupees. Separate instruction shall be issued regarding procedure for disposing these cases. Now, this procedure they are giving, procedure required to be followed by assessing officers to comply with Supreme Court judgments. So I think, the Supreme Court judgment has been, twisted and turned by the court to suit their requirement, basically. They are still relying on TOLA. What are they telling? See, the high courts, 2 months, 3 months, they took hearing. Beautiful judgments are rendered, 9 high court judgments. Clearly, they discuss the law. That, notifications cannot override an act which is already passed, cannot override a statute. Now, what are they telling? And Supreme Court rightfully told that 148 shall be issued as 148AB, fine. But when after they are telling 148AB, they are also telling all defenses under 149 are available to the revenue as well as to the assessing officer. So, your assessees. So when I go as an assessee, it is crystal clear, Finance Act 21, I will not be able to, you will not be able to issue notice for 13, 14, 14, 15. Even 10 years, I am telling you, my dear friends, 10 years is also not possible. Because beyond 15, 16, you cannot issue. Why? Even 10 years, beyond 15, 16, 14, 15, 13, 14, you cannot issue. 10 years will be only in future. You cannot go beyond 15, 16 today at all. 10 years also will come only in future again. Anyway. So moving further, issues and controversies, you can spend some time. What all issues may come. So earlier, the notice on 148 was quashed on the reasons that the same have not been issued under the Amended Provisions Act with effect from 1st April 21, controversy number 1. Earlier, it would have been quashed because High Court have quashed all your notices. You have filed writ that 148, you have issued under the old provisions. You have not issued under the as per amended provisions with effect from 1st April 21. High Court would have quashed such writs. Now that notice is deemed to be under 148A, B, and therefore, separate order has to be passed 148AD in all 90,000 cases. All 90,000 cases, all the notices, whatever reason disposing objections or assessment or everything is quashed. And now separately 148AD they have to prepare. That means what? Again, this 148AD, if such order is passed without following prescribed procedure, that means 148A, anyway, inquiry is dispensed with. 148AB, show cause notice, 148C, you are giving opportunity to the assessee, and 148AD, considering the material available on record and information submitted by the assessee, you are going to pass an order. And you have not considered the reply of the assessee against principles of natural justice without following the procedure, will become a non-speaking order. And in such case, again, the assessee has an option to file a writ. Because 148AD, appeal is not available under 246A of the Act. All and only thing you can do is to file a writ. Therefore, the issue will become more subjective rather than generic as earlier. Second issue. Now, Supreme Court has clearly observed that the defense as per 149 as per Finance Act and under law shall be available to both revenue as the assessee. So as far as assessee is concerned, that means what? If the case which could have been opened up to 31st March 21, it cannot be opened after 1st March 21. This is what? Because of the first proviso to 149 applicable with effect from 1st April 21. That means the cases for 13, 14 due to extended period of 6 years plus 1 year because of TOLA. And for 14, 15, 6 years from the end of assessment year could not have been opened after 31st March 21. Hence, the same cannot be opened with effect from 1st April 21 as per the first proviso to section 149 as applicable with effect from 1st of April 21. But this is twisted there in the board instruction. This fact is twisted, saying that because of TOLA, again they have gone beyond beyond 3 years and up to 10 years. Now, however, for other assessment years, that is starting from 15-16 onwards, date for issuing notice under 148 was applicable even after March 21. Yes, 15-16, 6 years from the end of assessment year, March 22. Hence, the first proviso shall not be applicable in such cases, and therefore such cases can be opened in view of the amended section, no problem. Now, if you see, third controversy, I am discussing what stand the department may also take. Not necessarily is my stand. Department need not necessarily, adhere to my views. So department also stand, I am giving you the stand of department also. So you have to be careful in argument. Now the Supreme Court has observed, I told you defenses are available on 149. Literal interpretation is that although cases for 13-14 and 14-15 could not have been reopened beyond 31st March 21, in view of the first proviso 149, repeatedly I'm telling, view of first proviso to 149, you cannot reopen for 13-14, 14-15. But the same could have been reopened. The department is going to take the stand. If the escapement of the income therein is more than 50 lakhs, because with effect from 1st April 21, new section 149 was already in place. Income Tax Act permitted such cases to be opened till 31st March 21, but the Relaxation Act had extended the time to 30th June 21, and the words under law is of great significance. I told you under law means probably it may be the Relaxation Act. In other words, 148 notices issued between 1st of April 21 to 30th June 21 for 13-14 to 14-15 having escapement of income of more than 50 lakhs may survive and may be governed by decision of Supreme Court. This is what the board circular, board instruction. So I am giving you one more view. This is again creating controversy. It has to be tested at the courts again. So this is the view of the department and give one more view. This is what the court, this is what, it is for the courts to decide. Anyway, I have given you my view. I have also given you the department view. And also the board circular anyway is there. Now, as regards the department is concerned, the finding of the Honorable Supreme Court means that cases for 3 years from the end of assessment year, irrespective of the amount of escaped assessment, and cases beyond 3 years, but within 3 years, but within 10 years, can be opened only when the amount of escaped assessment is 50 lakhs or more for that year. The cases which are already opened will be governed by the observations of Supreme Court. And since the Supreme Court has observed that the order has been passed with broad consensus, matter may not be expedited further since it is stated to be a consent order. Anyway, I have my reservations and the matter may be, go off to a larger bench also, which I will, explain further. Now, reason to believe versus information in possession. So in the new reassessment, this is controversy number 5. In the new reassessment regime applicable with effect from 1st of April 21, as per the amended provisions of Finance Act 21, the much settled and established legal position in respect of mandatory condition of formation of an independent reason to believe of escapement of income by the jurisdictional assessing officer has now been replaced with the condition of what? Possession of an information with the assessing officer as per RMS strategy of the board or final objection of the C&AG, suggesting that income of the assessee has escaped assessment. That is with Finance Act 21. Since the impugned notices issued on or after 1st April 21 and up till 30th of June 21, under the old section 148, as per the Supreme Court judgment, shall now be deemed to be issued under 148A, as per Finance Act 21, mandatory condition of formation of reason to believe is now replaced with the condition of possession of an information as per RMS strategy of CBDT or audit objection, final objection of C&AG suggesting that income of assessee escaped assessment, Finance Act 21. Therefore, if the assessing authority is not able to establish that it is in possession of an information, you have to be careful, you have to, find out whether this information is an information. See, there is a difference, it's only an information, but that is not should be a merely information, it should be an information which suggests that income has escaped assessment. And that too, it should be as per the only 2 types of information, risk management strategy of CBDT or final audit objection, etc., suggesting that income has escaped assessment. Then all such notices which shall now be issued by assessing authorities under 148 in consequence of the Supreme Court judgment deeming the impugned notices issued under the old section 148 as issued under new section 148A are amenable to be considered as bad in law. Next, number 7. Some interesting, controversies. As I told you, who is going to give this information? This information will be given by the JAO, Jurisdictional Assessing Officers. Now the problem is who is going to issue the information, whether it is the Faceless Assessment Center or respective field officers. In fact, the other day, the Income Tax Gazetted Officers Association has, one of the points raised in that beautiful letter, very pertinent points by the association for clarification from CBDT. So that is one more, controversy. Now the eighth controversy, which is being raised in that letter, is during the period from 1st of April 21 to 30th June 21. This is the question raised by the Gazetted Officers Association of Income Tax. During the period from 1st of April to 30th June, notices were issued based on information from only 4 sources. That is from assessing officers, from other agencies. We saw that board circular also, from investigation wing, from inside portal, etc. So other than the information received from inside portal, no other source qualify for the criterion of flagged in accordance with RMS. Please remember, if the information now, when they are going to give you the information, when the material within 30 days, please see whether it is an information and what it should be the information. It should be only from the inside portal, RMS strategy, etc. It should not be from other AOs, from other agencies, from the wing, etc. You have to immediately, file your objections. No, sir, this is not information. Because I am now defending, I am now filing objection under the new regime. So that from other AOs, from other agencies, from wing, everything, it's not possible, sir. It cannot be an information. Because what? It has to be only RMS, risk management strategy, formulated by board. So other than information received from inside portal, no other source will qualify for the accordance with RMS. 8th controversy. 9th controversy. As we discussed, there are only 4 sources of information from where the assessing officer can proceed under 148. The issue which is debatable is what is risk management strategy and how is the information flagged and what is whether this information risk management strategy is available in public domain. See, in the risk management strategy, you don't know what is it. So much information is fed now, formulated by board. See, now what is happening? Suppose you are investing in mutual funds, you are selling shares, purchasing immovable property, selling immovable property, depositing cash in bank account, depositing cash in a current account, SB account, etc. So much information. So all this information is fed in that risk management strategy. And that risk management strategy may be updated daily, yearly, monthly, weekly. I don't know. So that is the internal, the internal what do I say, is the internal information of the department, which they are not sharing with the public at large. So therefore, you will have to necessarily ask, what is risk management strategy? Please give me what is risk management strategy and how information is flagged and whether this information is in public domain. Issue which further arises is that whether assessee can raise any objection that if the information is flowing to the AO from a source which are not mentioned above. So that is the 9th controversy. Now again, as I told you, the last controversy, 10th one. Now generally there are 5 types of cases as of today pending for section 148. Generally, one of them is the assessee, sir, who has filed writ petition before a court. Okay. Another person is assessee who did not file any petition before any of the high courts, but that fellow went and challenged the validity of notice before the JAO without relying on any of the decisions from those 9 high courts. Third person is an assessee who did not file any petition themselves, but after the verdicts of different high courts, they challenged the validity of notice before the JAO, relying on such decision of the high courts. Fourth type of assessee is, person who has not challenged the notice at all. Fifth type of assessee is assessee who has not challenged the issue of notice and filed ITR in response to the notice also. So issue arises. How to handle all these types of cases? Whether the AO is required to send the information and consequently pass order under section 148A clause D, followed by issue of notice under 148 to all the assessees as above, or to only certain segments of this assessee. All the cases needs to be separately analyzed by the assessing officer in terms of amended provision and the limitation applicable, and then only proceed towards 148A clause D. However, another challenge will come because, ITBA portal, wherein 148 notice is already issued. So that 148 notice now, that portal 13, 14, 14, 15, how will they open, sir? That portal, it's not allowing you 13, 14, 14, 15. Where is it there? So already 148 is issued. Now 148AB should be issued. And when was 148 issued under the new regime? Only after I issued 148AB, then 148 is issued. So now you are telling me that 148 has become 148AB. Therefore, after 148AB, you are going to issue an order on 148AD. Again, issue notice on 148. Please understand the complexity of the cases. 90,000 notice on 148 already issued, sir. And already transferred to faceless assessment. Now it will come back to your portal. What's come back? Whether we have to see whether that 148 issue comes back or a letter along with 148A B show cause notice comes in the registered account of the assessee. That too from the faceless assessment unit. And now after once it comes from faceless assessment unit, that information will be sent to Java again, and Java is going to again issue a notice under 148AB despite having issued 148. They are telling that 148 shall be deemed to have issued on 148AB. Therefore, the Java now, not the faceless assessment, Java is going to take all the information from faceless assessment, issue a letter along with the notice, because they are telling deemed to be issued under 148AB. What? 148. Then I need to file my objections. Then they'll pass 148AD. Once the Java passes 148AD, again it will be shifted to your faceless assessment center. So this ITBA portal, we don't know how it is going to work now. So there may be some modification, which will be required in ITBA portal to overcome this technical issue on the portal. Because 148 is already issued, as I told you. So now again they'll have to issue now. After following the system of 148A, anyway, that 148A dispensed with B, C, and D. Now one more important controversy, 11th and final controversy. I want to bring attention to your members. So see, I am just telling you all these controversies because what the courts will take the stand, we do not know. What lies in the womb of future, we cannot decide. These are all the controversies which are going to come up. These are the stands taken by the department. These are the stands taken by the SSC. We don't know now how the matter will escalate before the courts, and again how the litigation and what judgments will be pronounced by the courts. But you have to be alert as regards replying to the 148, every word, every comma, every exclamation mark, full stop, you have to read in detail. Now one more stand may be taken by the department. So several stands taken from the SSC, by the department, etc. Finance Act 22, I told you there is an amendment. That to retrospective amendment, they have already, Finance Act 21, whatever amendments were made by Finance Act 21, even before being tested before the courts of law, amendment is made in Finance Act 22, applicable from last year onwards. So the department will tell now, I will rely on Finance Act 22 because that is applicable from 21. But Supreme Court is telling Finance Act 21. Why? Because the department is very clever now. See there in that board, that circular board which came on 11th, they are never using the word asset there at all. Only 50 lakhs income. They are never using the word asset there. If you see that, I want to bring to a notice of all members. Why? Because they know Finance Act 22. In Finance Act 21, the word used was only asset. Finance Act 22, asset, expenditure, book entry. So in that board, if you see, word asset is not used. Only income more than 50 lakhs, finish. Anyway. So now one more, this controversy may arise here. They are telling scope and coverage of the meaning of the term information. Information, I told you, Finance Act 21, only 2 types of information, extended to 5 types of information by Finance Act 22. So by Finance Act 22, information 5 types, any information for the relevant assessment year, they remove the word flagged now. In accordance with RMS strategy formulated by board, any audit objection, information received under 1991, any information available to AO under scheme notified 135A, yet to be notified, and information requires action consequence of order of tribunal or court. Now, Finance Act 22 have further widened the time limit for issue of notice under section 148 to provide that a notice under 148 can be issued after 3 years up till 10 years. where the assessing officer has in his possession books, documents, evidence, which reveal that the income chargeable to tax represented in the form of asset or expenditure or entry in books of accounts, escaped assessment amounts are likely to amount to 50 lakhs or more in any or all of such assessment years. That means in aggregate and not per year as in Finance Act 21. So Honorable Supreme Court, what they have clearly stipulated the timeline for issuance of notice on 148 as per the amended provisions of Finance Act 21 and all other applicable provisions as per the amended provisions of 147 to 151 as per Finance Act 21 are to be complied with. Now, as per Supreme Court judgment, all such imputed notices issued after 1st of April 21 and up till 30th June under the old section 148 shall now deemed to be issued under new section 148A as per Finance Act 21. And therefore, the assessing authority is supposed to issue consequential notices under 148 after complying with the requirements of 148A and other amended provisions of section 147 to 151. Therefore, all such consequential notices under 148 shall now be issued at present, is on or after 1st of April 22, when the amended provisions of 148 are in place by virtue of the Finance Act 22. Again, problem now. Now I am issuing notice under 148. What is applicable? Finance Act 22 is applicable now. This will again lead to increased litigation if the revenue authorities adopt the extended definition of meaning of the term information as per amended explanation 1 to 148 as per Finance Act 22 to include any information and any audit objection, including that of Internal Audit Department, not just final objection of C and AG, etc., for reopening the cases for 3 years. For the impugned deemed notices in 148A, carefully remember one more sentence I want to add. If at all you are surveyed, my dear friends, if you are searched, etc., no question of 148A, it is deemed to be information. But if there is a survey, the department has to compulsorily, mandatorily follow the steps of 148A, B, C, D, even in case of survey. And up to 3 years from the end of relevant assessment year, notices will be issued. Be careful. Earlier for survey, only 1 year. Now 3 years returns you have to file. Now 3 years from the end of assessment year. And deemed information, survey word is not there. Deemed information. They are telling that beyond 3 years up to 10 years, there can be a search, there can be a survey, etc. Money, bullion, jewelry, books of account, documents, etc. pertains to, relates to, found in the case of other person, etc. But for the deemed information, if you see there, survey word is removed. Therefore, for survey, 148A dictum has to be necessarily followed. Keep it to yourself and object there. If they tell information, department income information, escaping assessment, you have not followed 148 ABCD, it becomes void ab initio procedure. Anyway, these are all the thought process to be worked upon in future. Now, this will again lead to increased litigation if the revenue authorities for reopening the cases beyond 3 years up to 10 years adopt the more liberal condition of Finance Act 22, presence of income exceeding 50 lakh rupees in any or all of the 10 assessment years and not necessarily in one assessment year as per the amended explanation 2 to section 148 as per Finance Act 22. But then if the department uses that, there is benefit for me also. If the assessee uses that, then benefit for the assessee also. Why? If the revenue, they make an attempt to adopt and make applicable extended scope of the term information and liberal criteria of spreading of except income of all 10 years. That is, your spread of 50 lakhs over all 10 years, beyond 3 years up to 10 years. As per the amendment made in Finance Act 22, on the ground that the notice on 148 consequential to deemed notice on 148A are now being issued on or after 1st April 22, then our assessees will also get equivalent right to argue that such interpretation will simultaneously reduce the validity of issuance of 148 notice, which are obviously issued on or after 1st April 22 for one more assessment year. That is in cases of alleged escapement of 50 lakhs to assessment year 1920 and in case of alleged escape income exceeding 50 lakhs to assessment year 1213. What about your complete justice as per Article 142 of Constitution of India? Now, because this is invoked by the Supreme Court here for a tax matter, as far as I remember, it was way back in Greenwell Corporation, Bombay High Court, Supreme Court used that power or under Article 142 exercised. Now, Part 5 of the Constitution discuss about the Union and Chapter 4 of this part discuss about the Union Judiciary. Article 124 to 147 are part of the Chapter 4. In the normal course, judgments of Supreme Court are covered under 141. Article 141 states that law declared by Supreme Court shall be binding on all courts within the territory of India. So now Supreme Court can invoke Article 142 for doing complete justice. Article 142 reproduced as follows. So 142, this is the, Article 142, this is the meaning. So they are telling, Supreme Court in exercise of jurisdiction may pass or make any such order as is necessary for doing complete justice in any cause or matter pending before it. And any decree so passed or order so made shall be enforceable throughout the territory of India in such manner as may be prescribed by or under any law made by Parliament, and under any provision this behalf is so made in such manner as the President may by order prescribe. But here, my dear friends, already there is a statute. Already there is a statute which is existent. Now, anyway, so what is basically the purpose of Supreme Court here for accessing Article 142? To grant relief, to do justice in a given case, dehorse the applicable statutory provisions. Already applicable statutory provisions are there. The amended provisions of Finance Act 21. And to issue directions to fill what the court perceives as legislative gaps, which directions operate as the law of the land until such time that the legislature or executive steps in. Already law is passed, sir. Where was the necessity? Finance Act 21 was passed. Provisions were crystal clear. So now you see, majority of the cases, powers granted Article 142 of the Constitution of India has been exercised by Honorable Supreme Court, majorly in cases of public interest and social justice unrelated to tax laws. So landmark judgments were power granted under Article 142 exercised by Honorable Supreme Court. This is in A.R. Anutule's case. They exercise this 142 article. Supreme Court can grant appropriate relief when there is manifest illegality and that there is manifest want of jurisdiction where some palpable injustice is shown to have been resulted. Such a power can be traced to either to Article 142 or a power inherent to the court as a guardian of the Constitution. So like this, many judgments are there. We discussed that Union Carbide also. And about Ranjanam Bhumi Ayodhya case, which we discussed. Union Carbide case, Bhopal gas tragedy, etc. All this, Article 142 was invoked. Then Manohar Lal Sharma is your coal block allocation case, where, the Supreme Court once again invoked Article 142 to cancel all the allocation of coal blocks granted from 93 onwards, etc. Now, there is a landmark judgment of Honorable Supreme Court on limiting factor on invocation of Article 142. What is the limiting factor? ESP Rajaram versus Union of India, which has beautifully analyzed the direct discretion and limitation of the invocation of power granted in Article 142 of Constitution of India, and has held as under. The exercise of the power is left completely to the discretion of the highest court of the country, and its order or decree is made binding on all courts or tribunals throughout the territory of India. However, this power is not to be exercised to override any express provision. Honorable Supreme Court is telling this power is not to be exercised to override any express provision. There was already express provision here in the Finance Act 21. Already the new amended provisions of 147, 149, 148, 148A, 151 are in place. It is not to be exercised in a case where there is no basis in law which can form an edifice for putting up a superstructure. Court has not hesitated to exercise the power under Article 142 of Constitution whenever it was felt necessary in the interest of justice. Then, M.S. Alawat again, bench of three learned judges of this court, considering the power of the court, and referred to its, this is in case of criminal case, referred to relevant observations of Supreme Court Bar Association Union of India 1998, held that under Article 142 of the Constitution, Supreme Court cannot altogether ignore the substantive provisions of a statute and pass orders concerning an issue which can be settled only through a mechanism prescribed in another statute. So I have given all the judgments. Now you connect that 142 in Supreme Court case of Union of India versus Ashish Agarwal, judgment delivered on 4th of May. Last 5 minutes and I would stop. Invocation of Article 142 in Supreme Court case in the case of Union of India versus Ashish Agarwal. Now, if you see here, before invocation of Article 142, Revenue was able to canvass and also convince the court that amended 148A is a procedural in nature and not substantive. Once the law is declared to be procedural in nature, then that open a wide ambit to the judiciary to modulate in such a manner while with the object of complete justice so that substantial right is not impeded. The Revenue relied upon para 65 to 67 of Delhi High Court in Manmohan Kohli, rendered last year, wherein it was held as under para 65, para 66, 67, etc. Judgment, all notices were quashed, etc. So when you view further, Supreme Court judgment may need to be reviewed. I have also given, we have our own reasons. Maybe may need to be reviewed or referred to the larger bench for the following reasons, etc. Irrespective of whether they have been assailed before this court or not, curtail the fundamental rights of the assessee. Now 90,000 assessees, 90,000 notices, rights are curtailed now. Because 9,000 notices matter of writs would have been quashed. Fundamental rights of the assessee. The same do not fall within the phrase in any cause or matter pending before it under Article 142 of the Constitution. Because only 9,000 writs were there. What is this court telling? Whether in any cause or matter pending before it, whether 90,000 notices were pending before it. Article 142 does not provide the Honorable Court to issue order repugnant to the statute. We discussed A.R. Antule versus R.S. Nayak. It was held that Article 142 is not of much assistance. In first place, operative words in that article again are in exercise of its jurisdiction. So it is one of the contentions of the appellate that an order of this type, far from being necessary for doing complete justice in the cause or matter pending before the court, actually resulted in injustice. However wide and plenary the language of the article, the directions given by the court should not be inconsistent with or repugnant to or in violation of specific provisions of the statute. Anyway, these are all, jurisprudence. So, again in Premchand Garg versus Excise, rendered 1963, power under Article 142 of Constitution of India must not only be consistent with the fundamental rights guaranteed by the Constitution, but it cannot even be inconsistent with the substantive provisions of the relevant statutory law. Moving further, sir. Now, for your information, there are 2 writs already filed under 148 AD. Writs are filed. I am giving you the judgment. Already writs are filed in 148A Clause D. One is in New Delhi, Bharat Heavy Electricals Limited, BHEL versus Principal Commissioner. Judgment has come on 25th of April 2022. Writ petition was filed 148 AD. Challenging the order dated 31st of March 22, passed on 148 AD, and notice dated 31st of March 22 under 148. So, along with the order on 148 AD, along with the notice comes 148. So, writ was filed. And see here, now, the learned counsel, how he argued for BHL, is telling that petitioner is a reputed PSU. They have been awarded Maharatna status in the past. It further states petitioner, is under directly supervised by union government. It has got strict internal controls. It states that the petitioner had filed return of income 1,707 crores for assessment year 18-19. That 3 years from the end of assessment year. He also states that the petitioner is subject to dual audit under Companies Act as well as by CAG. And they have been given a clean sheet for assessment year 18-19. Also emphasizes that complete scrutiny assessment has been done in the case of petitioner or relevant assessment year. So therefore, the court has now given what a stay, praise for a complete stay and permitted to file counter affidavit, etc. Rejoinder affidavit need to be filed before next date of hearing. Keeping in view the aforesaid, this court is of view highly unlikely that the petitioner would be engaged in input tax credit fraud as alleged by the respondents. Accordingly, till further orders, no action shall be taken in pursuance to the impugned order and notice dated 31st March 22. Next date of hearing, they had given 3rd November 22. Now everything is anyway 90,000 notices. That is only if it is issued between 1st of April 21 to 30th June 21. That is different. So this is one, 148 AD, how people have gone already, even against the new order passed on 148A under new section 148 AD. Again, Gulmore 6 Private Limited, recently, 7th April 22. Honorable Justice Manmohan and Honorable Justice Dinesh Kumar Sharma. What are they telling here? The impugned order 28 March 22 is a non-speaking order. Petitioner is telling non-speaking order does not deal with the contention raised by petitioner. In support of the submission, the petitioner relied on judgment of Supreme Court in Kranti Associates, etc. And then he states that the impugned order 28 March 22 has been issued in a mechanical manner and without any independent application of mind. I am going through this order so that you get some ideas and how writs are filed even under the new regime of 148 AD. In this, the petitioner is telling order is passed mechanical manner without any independent application of mind by placing reliance on the information provided by the wing, which does not have any rational nexus with the petitioner. In this, what mistake they are telling states that the information mentioned in show cause notice, it pertains to assessment year 14-15, which has been used to frame reason to believe. Information for 14-15 is used to frame reason to believe for escapement of income for 18-19. So what is the court giving the judgment now? Court is telling pertinently assessee has submitted only bank statements and not books of account before the AO. Further, this court is of the view ratio of Supreme Court in Raymond Woolen Mills versus income tax, old judgment delivered in 2008, Bombay High Court, clearly attracted to the facts of the present case. In the judgment, what was it, sir? In the judgment, the court told that when you commence reassessment proceedings, what prima facie you have to see whether there is any prima facie material, etc., based on which department can reopen the case. The sufficiency or correctness of the material is not a thing to be considered at this stage. So therefore, though it is the petitioner's case that the impugned order is erroneous on facts, yet this court is of the opinion that the petitioner would have ample opportunity during the proceedings before different statutory forum to show that the finding of fact arrived at was erroneous. Court is telling go back to the assessing officer, make out a case there. Moreover, this states no assessment order has been passed and it has only been observed that it is a fit case for issuance of notice on 148. Then the court is telling, in fact, the Supreme Court in Commissioner of Income Tax versus Chabil Das Agarwal has held that as the Income Tax Act 61 provides complete machinery for assessment, reassessment of tax, assessee is not permitted to abandon that machinery and invoke the jurisdiction of High Court under Article 226. At the end, sir, I am ending my session to remind the department taxpayers charter. So you know the taxpayers charter which came into position 2 years back. Committed to provide, income tax department committed to provide fair, courteous, reasonable treatment, treat taxpayers as honest, etc. Provide mechanism for appeal review, provide complete and accurate information, provide timely decisions, collect correct amount of tax, respect privacy of taxpayer, maintain confidentiality, holds his authorities accountable, enable representative of choice, provide mechanism to lodge complaint, provide a fair and just system, publish service standards and report periodically, reduce cost of compliance, and also expect the taxpayers to be honest, compliant, informed, keep accurate records, know what the representative does on its behalf, respond in time, pay in time. So whether I am telling my humble opinion, whether you are following the taxpayers charter. Anyway, so these are all issues and controversies, related to 148, 148A, 149, 151, which, and based on the Supreme Court judgment and also the board circular, which has come yesterday. So we have discussed a broad concept. I thank the Bangalore branch once again for having, giving me an opportunity to allow me to deliberate on the Supreme Court judgment. Thank you for a very patient listening to all the members. Thank you.
Thank you, Naveen sir. It was an excellent presentation. Members, we have come to an excellent presentation. Within a short period, when we requested Naveen sir to come and address our members on a recent judgment of Supreme Court on 148, he immediately agreed our invitation and agreed to come and address our members. I thank Naveen sir on behalf of Bangalore branch of ICA. I request our MC member Rejo present a gift voucher to the Naveen sir. Thank you, Rejo.
Thank you, sir. Thank you.
I thank all the members for actively participating in this program and making it successful. There is a small notice that tomorrow we have a program on US taxation for individuals. I request members to register for that program. Thank you. Thank you, one and all. Thank you, sir.
Thank you.